We do have a decision from the 7th District Court of Appeals in a case called Walker versus Noon. One of the many issues that was raised in that case is the constitutionality of the vesting of mineral interests in the surface owner absent certain notice provisions. That's a big issue. Another potential issue is retroactive application of law. Some think that, well, if this mineral estate vested in the surface owner back in, say, 1995, when the '89 version of the Act was in effect, then applying the 2006 version of the Dormant Minerals Act against that interest would be a retroactive application of law. That's another important issue that courts haven't had a chance to weigh in on yet. So those are some of the core issues that will be raised to the Supreme Court of Ohio in Walker versus Noon. There are, however, 2 additional cases currently on appeal to the Supreme Court of Ohio that bring in Dormant Minerals Act issues, but they're much narrower. One of those is the Chesapeake Exploration versus Buell case. In that case, the federal court for the Southern District of Ohio asked the Supreme Court of Ohio to certify a couple of questions of state law for its purposes in a proceeding. One of those questions, at core, those questions involve whether a lease of oil and gas counts as a title transaction for purposes of the Dormant Minerals Act, our revised code 5301-56. So we'll hear from the court soon on that issue. Another case before the Ohio Supreme Court in which these more narrow Dormant Minerals Act issues have arisen is a case called Kroski versus Dodd. In that case, the Supreme Court of Ohio decided to hear just a very narrow issue on what counts as a title transaction under revised code 5301-56B3, which is a relatively narrow issue regarding title transactions. Ryan can tell you a little bit more about title transactions generally.
Well, the question really is what constitutes a title transaction, because that's a savings event under the statute. If there's been a title transaction within the preceding 20 years, now there may be some dispute over what 20-year period, but let's just say over the preceding 20 years from the attempted abandonment. If there's been a title transaction, then the minerals stay with the mineral owner and won't vest in the surface owner. But what is a title transaction? Is it a lease? Is a lease of the mineral rights a title transaction? Is a reference to those several minerals on a subsequent surface deed, stating very clearly that the minerals were reserved in a prior deed? Is that a title transaction? Those are the questions that are still outstanding, and some of those are actually headed to the Supreme Court here in the near future.
The reason that's important is because if certain things are or are not title transactions, that can be entirely the deciding factor as to who owns the mineral rights. Because if the answer is yes, then a savings event occurred and those rights have been preserved in favor of the person that reserved those rights so long ago. If the answer is no, then those rights have not been preserved. They were not subject to a savings event, and they may have vested in the surface owner.
Now, in addition to the vesting in the surface owner through the absence of a title transaction, there's also the ability to file a preservation affidavit as the mineral owner under the statute, saying, basically restating your interest in the minerals and putting that of record so that they can't be abandoned. The preservation affidavit may be done, may be filed by the mineral interest owner kind of at their leisure within a 20-year period leading up to 1992 or since 1992 coming forward. The issue is that the minerals haven't been identified as that valuable until recently, really the last 3 or 4 years. So mineral interest owners weren't filing these preservation affidavits. They didn't have the financial incentive to do so or to know whether they were even in compliance. What's even more tricky is in the 2006 version of the Dormant Minerals Act, the mineral interest owner has the opportunity to file a preservation affidavit after they've received notice from the surface owner. But really, both parties can comply, and then you're stuck in a position of uncertainty once again.
The Walker versus Noon case was a case that came from originally from the trial court in the 7th Appellate District, and then it was on appeal before the 7th Appellate District. We represent Noon in that case. That case is the first case to bring some really central issues to Ohio's Dormant Minerals Act before the Ohio Supreme Court. One of those important issues is whether and how to apply the 1989 version of Ohio's Dormant Minerals Act, which was superseded in 2006 in an action brought today The way that you answer that question entirely determines who owns the mineral rights on a given parcel of land.
No, it's critical, and there are so many companies that have taken a position on either side of this issue as they seek to develop the mineral interest, some going so far as to take protective leases from the surface owners in the event that the court decides that the mineral rights have automatically vested into the possession of the surface owners.